Yes. Very important further aspect. With the experience of hearing the cases against doctors, of course, let me tell you, the merit of the case guides the bench or those who are sitting here as judges to decide a case. For us, it is either in favor or against a doctor. So it is the merit which decides the decision or final outcome of any case. Whenever, in one case, just to share with you, there was an appeal against the medical negligence case which was decided in favor by a district consumer commission, and there was an appeal which came out for a final hearing. See, the advocate who was representing a patient was a very senior lady, and with her experience, she brought out 22 grounds of appeal. How many? 22. So that means why the appeal is being filed? There were 22 different grounds which were found by the advocate. So role of advocate definitely is important, and asking why to each and every document which we have placed before the court, that is the thing which leads to the further, for us, either a complication or leading the case further to the complex level. So this is the only thing which, so I was very much surprised to find that for a case there can be 22 different grounds. That means we should be so much aware. Now with certain further experience, when the advocate representing a doctor, when a question was or even used to be asked that where is the medical record? In number of cases, medical record was not found. And I'm sure sir is also having the same experience. So medical record absent. Where is the consent? Consent is not there. Or nothing has been filled, only some thumb impression or the signature has been taken. So this happens even today also, and it's very difficult to actually think about the medical professional safety. So, of course, though I'm a surgeon, sitting on that side, you will find that it is the merit of the case which always takes an importance. So when the document is not there, and you all will agree that what defends you in the court of law is document. It is the document, so you must spend some time for proper documentation. Now coming to the very important topic, this is defending yourself in the consumer court. Understanding the consumer courts, as already discussed, that there are this is a three-tier system. Now with the new act, all the complaints will now lie before the District Consumer Commission only. Because if the consideration, that means amount of fees or whatever has been paid is up to 50 lakh rupees, then such case or such complaint will always lie before the District Consumer Commission. So all cases now will be before District Consumer Commission. State Consumer Commission, appellate authority, appeals against the orders of District Consumer Commission are placed before the State Consumer Commission, and appeals against the State Consumer Commission will go to the National Consumer Commission. Now one more change is, if suppose the District Consumer Commission passes an order and asks to pay say 50 lakh rupees or even say 20 lakh rupees as a fine to a doctor. While going in an appeal, as per the provision, 50% of the amount one has to pay to the commission, the deposit, and then and only then the case can be filed. So this is also an important aspect which one has to remember and know. Reasons why the cases are there, everybody will agree that now the awareness has been increased, there is a media influence and the legal accessibility. So whenever, for any reason, any person thinks that he is aggrieved, because of doctor's behavior, you all will agree that doctor's behavior is very important. So if anybody is aggrieved, even if the outcome is good, the person approaches consumer court because it is very easy to access the consumer court and try to harass the doctor. So this happens. So we have to take very much care. What are the common allegations against doctors? Misdiagnosis, surgical errors, medication errors, and lack of informed consent. So we have just now heard about the consent as such. So it's a very important topic. Now, no consent is foolproof. So whatever guidance is there that this should be done, that should be done, that should be done. Even if we do this, the consent can be proved to be not proper by the advocate in the court of law. Right? But still, we have to take maximum care. Who should give consent? It is the patient himself only. Nobody else. If anybody else gives consent, it is a proxy consent. Secondly, whether treating doctor should sign? Yes, treating doctor is a must, he should sign. No ward boy, no sister, nobody else should sign. 3, whether the witnesses should be there? Yes, at least 2 witnesses should be there who should certify rather that this consent has been taken. And the name of diagnosis and name of the surgery advised, what has been options for this particular treatment, and what are the complications of this particular surgery or the treatment. That should be mentioned, must be mentioned. So it's like that. So informed consent should be there. Now in one of the National Commission judgment, you might have, of course, this was challenged here, yet it is to be finally decided that the pre-blanket consent is not acceptable, or pre-printed consent is not acceptable, was one of the order in the judgment from National Consumer Commission. Now what we have to, till it is decided, we should now modify our own practice so that at least some part should be in written, preferably in the patient's handwriting. There can be number of options and we can say solutions to this particular consent. Now gradually audiovisual consent is becoming we can say very important as such, and that will definitely help the doctors. Now one of the most important aspect which I now wish to place before you, that in consumer courts you as a doctor can defend yourself. Do you know this? Do you know this? So the advocate represents you, yes, but still if you as a defendant, if you study the case, see, I am of the opinion that the medical study and the medical profession is the highest one. So the talent which is required to study medicine is highest one. So it's not difficult to study law and get to know the intricacy of how a court case or consumer court case is there. Okay? There are 3 stages of any consumer court, consumer court case. The first one is a stage of pleading. Patient files a complaint. Doctor responds to it or replies to it. Of course, it should be within 45 days, the written consent needs to be filed. This completes the stage of pleading. Second stage, stage of evidence, in which the evidence means medical literature, expert opinion, and the documentation as such, medical records. So these 3 primarily form the evidence as such. So the filing that on behalf of the doctor as well as the whatever documents are there, filing those documents completes the stage of evidence. Third is stage of final hearing, in which both the parties need to file short summary, we can say, notes of argument, and then it is argued before a bench. Advocates represent both the sides. Whatever knowledge the advocates gain from doctors, they try to explain it to the judge, right? Now, I think, see, I have heard few of the doctors arguing before me, And I think that it is the doctors who should defend themselves in the consumer courts. Is it difficult? I don't think it is difficult. Of course, you can take the help of advocates, but you must know the technical aspects and you must learn how that is to defend yourself. So anticipating an argument and addressing the counter arguments is a technical aspect which is definitely possible to learn. Now for which now I am coming out with, this is an important point, that defense skills can be learned, and I am now coming out with a program of 6 weeks in which online and offline I am going to not only teach, but there will be former judges who will be involved, who will teach you the skills to stand in the consumer court. So this is just an information. And so the formal take-home message is that the doctors themselves must stand in the court. Number two, it is not at all necessary to have a fear of any court as such. It's definitely possible to stand out there and speak on your behalf. So I think that this is quite important. Now, I'll need five more minutes. 40 minutes over?
No, sir, you have 8 minutes. 7 minutes more.
Okay. Right, so then I can show the presentation as well. Good. तुमच्याकडे हे नाही आहे हां स्लाइड मोर हां ठीक होत आहे.
Sir, question and answers will be taken at the end of the session, sir, in 15 minutes.
Simplest thing is, see, even if I read it in English, I can say I didn't understand because this is not my language. So that's the reason no consent is foolproof. But if at all, apart from English, you also take the consent in the vernacular language, native language of that particular person, it will be useful. So 2 languages will definitely be useful one. Yeah, working, not working. Okay. Now, coming to one more concept. See, there can be n number of things which can be done in the help and defense of a doctor. Of course, no profession can be so much, we can say, involved in the life of a patient as medical profession is, right? So, in this profession, definitely nobility is still remaining. As it is said, that black sheep are there in every profession. We all are aware about it. But then we don't want to talk about it because they face the music of law whenever their time comes. Those who wish to practice the medical profession for the sake of patients, they need to take a good care of themselves by knowing, understanding various legal provisions, and as far as possible, you have to, we can say, take care of the relatives as such, right? So patient and the relatives, there should be a good doctor-patient relationship. Now, you must have heard this so many number of times. So, coming to another concept of grievance redressal mechanism. So, this mechanism, if we establish in our hospitals, even in our clinics, we define it. Nowadays, fortunately, The quality management parameters like ISO, NABH, etc. So they deal with the setting up certain systems in your hospital and clinic. To that, grievance redressal mechanism is one more concept which should be there in the hospital. If we introduce this mechanism in our hospital, I am sure this will definitely reduce the number of complaints and the cases against the medical professionals, against the hospitals as such. So how it should be done? It should be a transparent one. The system must be known to the patient as well as hospital employees and the doctors. Timely resolution with effective communication is quite important. No, it is not, it will not be overestimation of the effectiveness of the grievance redressal mechanism. But definitely, the satisfaction of the patient and the relatives will definitely be improved. One must be aware about the legal and regulatory framework. And see, one more, one suggestion is that whenever we take a consent, so the first consent gives the agreement with the patient, or we can say in even legal language, it can be a contract between doctor and patient. The very first, whenever patient comes to the hospital, you definitely can mention there that in case of any dispute, please approach grievance redressal mechanism of this hospital. Second point is, the arbitration is available. Alternative dispute resolution mechanism is available. So if you mention this and take a proper consent or proper signature, I am sure this can be introduction of certain alternate dispute resolution from our side. And I am sure even the courts will accept that, and they will say that this you have accepted and agreed, so you please go for that. This happens. So this is another suggestion. Grievance redressal mechanism, of course, it's a voluntary thing. The senior doctors must get involved. The administrators and even a law officer must get involved in this. So in that, what happens is, it takes care of the diffusal of the grievance of the patient. Now, there must be a system. I'm not going to much into the details of this system. The roles and responsibilities should be decided, and the investigation process must be protocolized. Timely resolution and feedback must be there. The best practices of grievance redressal must be implemented, and of course these are the words from a quality management system. Continuous improvement and monitoring must be there. So establishment of grievance redressal mechanism in a hospital, even in your clinic run by one doctor, will definitely help. That's what I think. And obviously, see, in Pune, what I did before joining as the member of the State Consumer Commission, I started one system. The first system is that a team of doctors supported by team of advocates. So 8 to 10 doctors who are definitely interested in welfare of the medical community and want to spare the time for the doctors. This team, supported by the team of advocates, young advocates, in any of a legal issue or a problem, immediately rushing for helping the doctor or the hospital. So this is second. Third one, of course, you are aware that the professional indemnity insurance is very important. Now you have to have, of course, it will take more time to discuss that, but having professional indemnity insurance. Fourth is the violence in the hospital. So how that can be prevented? So any amount of, see, applications and any amount of, it's very difficult to stop the violence. So why not to establish or have a system in place which is built up by us only? The IMA has a system, Pune IMA has a system or concept called rush team. The doctors, immediately 5 to 10 doctors, they rush to that particular place. Under the guidance of the then Director General of Police, Mr. Praveen Dikshit, we started one system in Pune. Of course, I developed teams of retired police officials in 10 places, 10 districts. So rather than we doctors running at particular place, why not the others work for us? And retired police officials, they are the best ones we could diffuse a number of incidences at least 3 places. So that is again a solution which can have established and protocolized here. And last one is the academic upliftment of our own knowledge. So this, as Dr. Masari sir has actually brought to all of us, the doctors of NANDED, maximum attendance to such CMEs where you will get the technical legal knowledge. It's quite important to attend all these, all such things. So with this, let me stop here because the time is up. If you allow me, I will talk till 10 p.m. I will not be definitely, rather I will be happy. But there are so many experts who are sitting in the audience. I'm sure we all are very eager to listen to them. So with this, let me thank Dr. Masari sir, Dr. Prahlad Kotkar, Dr. Sunil Chandolkar, who has also adjusted his time, and so I'm very much thankful to him, and all of you who have patiently listened this particular talk. I'm thankful to you. I'm there for any kind of your, we can say, query or something. So I'm there even in the afternoon session. So we may discuss about that. So I thank everybody.